Good evening, good afternoon, good morning, wherever you're connecting from. Um, I'd like to welcome you to this webinar being hosted by the Pharma Committee. Um, this is part of a global series of regional panels the Pharma Committee has been organizing. The first one, and sorry, it's regarding the availability of discovery mechanisms in different jurisdictions to aid in the preparation of preliminary injunctions or just general evidence gathering. Our first regional panel was held during the 2024 spring meeting in Madrid, where we had colleagues from the Unified Patent Court, from Italy, from Poland, and Spain. And now we're switching over to a different part of the world, Asia, and we are going to have speakers, some colleagues from China, Japan, Korea, and India helping us out in this presentation. Um, First, some housekeeping. Um, we are going to be taking questions from the audience at the end, but you're welcome to start submitting those questions for the speakers via the Q&A box, which is a Zoom feature that you have available. And if you have any technical problems, please send a message via the chat box, which is the other Zoom feature to AIPPI events. And once we disconnect, there will be a survey after the webinar, which we kindly ask you to fill out to provide some feedback for our AIPPI colleagues as well as ourselves. Thank you. Um, Today, again, we have speakers from Asian jurisdictions, and I'm going to be following the order which they will be presenting in. And first from China, we have Xinlei Wang from CCPIT. She is a patent attorney and attorney at law, and she specializes in various technical fields, including organic and inorganic chemistry, medicine, and pharmaceuticals. Following Xinlei, we have from Japan, Takanori Abe. Takanori is the managing partner at Abe and Partners. He's an attorney at law. He's admitted to both Japan and New York bars. And one of his strongest fields is pharmaceutical patent cases. Following Takanori, we have Duck Soon from Kim and Chang, Duck Soon Chang. He's an attorney at his firm, and his principal practice includes IP litigation, technology licensing, antitrust, and international arbitration. Last but not least, from India, we have Archana Shankar. She's from Anand and Anand in India. She has extensive experience in all patent-related matters, including prosecution and contentious work, especially in the fields of bioinformatics, pharmaceuticals, biotechnology, chemical, and regulatory issues. Rounding out, I'll be moderating. My name is Carlos Olarte. I'm from the Olarte Motive firm in Bogota, Colombia, and I've been pretty involved in pharmaceutical litigation as well. In order to tee up the presentations, I have prepared some slides that will present the general issues we're going to be talking about and what we prepared um, for this particular presentation for the panel. We probably one of the biggest difficulties we had preparing the presentation was defining what discovery meant. So here are just a few bullet points regarding the definition that we came up with. Was one was a mechanism, a legal mechanism, to allow for evidence gathering to prove certain facts that are necessary to meet a legal burden. So it didn't necessarily need to be judicial, and we're going to have some non-judicial options that we're going to discuss in some of these different jurisdictions. Also, it was necessary that there be some obligation to provide this information. And typically that comes from the judicial branch. But the idea was, how can we judicially compel the production of documents and information? So that's the general gist of what we were looking for, not really the formal definition of discovery that's available in some of the Anglo-Saxon jurisdictions. We also discussed that without discovery mechanisms, parties were left to obtain information solely from public sources or witnesses willing to cooperate. And what that meant was, potentially, is if we do not have formal discovery mechanisms, many times it became impossible or impractical to comply, to meet an evidentiary burden and be able to show infringement, be able to obtain a preliminary injunction. And this, in many cases, could potentially leave a patent holder without effective legal recourse to enforce its rights. Some of the general mechanisms that we identified, not necessarily in all of the jurisdictions which we discussed, were motions or mechanisms designed to preserve evidence. That's obviously available in some European jurisdictions. We discussed depositions, written interrogatories, production of documents and samples was pretty important. In general, for many of these mechanisms, the scope was limited by the relevance of the information in connection with the facts being alleged in the complaint, or if the mechanisms were allowable before a complaint was filed, that future case to be filed. One of the bigger points also was confidentiality. One of the big obstacles many times in a lot of jurisdictions is that there's a big public policy argument protecting confidentialities. And in an effort to overcome that, sometimes there are mechanisms available to protect that confidentiality. In particular, for example, protective orders to ensure that the information remains secret. Um, the relevance in particular to pharma regarding these issues is that there are serious evidentiary challenges when the patent relates to non-compound inventions. In other words, when we're talking about a patent that directly covers the compound, typically there's not going to be a lot of discussion regarding, whether or not the API is in the tablet or whatever, right? However, when we start meeting or engaging patents that are not related to the compound, and they're not available for inspection and testing prior to launch, those cases are going to be more difficult. So we, mentioned processes, formulations, polymorphs, isomers, those sort of inventions, those pharma inventions. And even where that information is available, and even in cases where, the potential of the burden of proof being inverted, the access to that confidential information is still necessary to fully prove the infringement. So those are the challenges in particular in the pharmaceutical field. So what we'd love the audience to take away from this presentation is, what discovery mechanisms or pseudo discovery mechanisms, whatever you want to call it, exist in the different jurisdictions, and what the differences are, and what are the advantages and limitations of those mechanisms in these jurisdictions, and how can you tailor your litigation strategy accordingly. So with that presentation, I'd like to hand it over then to Sinlei, who will start us off with China. I'll stop sharing my presentation.
Thanks, Carlos. Nice introduction. Hello to everyone who's watching this webinar. In my next several minutes, I'm gonna share with you some of the basic facts about the evidence collection in China. So let me share this. Okay, so just before I jump into the details, quick answer to Carlos' question about whether there is a discovery mechanism in China. So basically, we don't have a typical US style discovery mechanism that would produce tons of documents for each of the party. But we do have general judicial mechanism to push the party to submit necessary documents to assist evidence collection. Okay, so with this said, and another thing I would like to clarify before we touch the details of the evidence collection is actually because Carlos mentioned preliminary injunction, the PI. I would like to clarify two things. So first of all, the PI procedure in China is actually not an independent procedure. It is part of a civil suit procedure. So as you could see in the flow charts, the top line flow charts here. So in China, the PI, the preliminary injunctions, is usually referring to the one filed before suit. And there is also an interim injunction, which is referring to the one filed during the suit, but before the final verdict being issued. So there will be two time points for the patent holder to file an injunction for the verdict. And if a PI is granted, as you could see here, the flow charts, the civil suit has to be filed within 30 days since the PI is granting. Otherwise, the PI will be dismissed. And the patent holder might even have to compensate the loss of the accused infringer due to the PI procedure. So this is something might be special in China. And also to grant a PI, the court will take into these factors as I listed here, which I think should be quite similar with other main jurisdictions. But since it's not the topic today, I'll just leave it here. Okay, and the second thing I want to clarify is in China, the patent infringement disputes could be solved in two ways. So first, quite common as civil litigation before a court. And second, we also have an administrative action, which we call it AA, before a patent office. It could be local patent office or it could be state level patent office, depending on how big the case is. Okay, so the main difference between the AA and the civil suits is that AA is much faster. As you can see, the lower flow charts here. It could be ended within several months, like 3 to even 4 months. So it's very, very faster than the civil suits. It can stop infringement very quicker. But the downside is AA does not reward damage to the patent holder. So it's basically some injunction, but it's from the patent office. So this kind of action is suitable for cases that are technically clearer, simpler, and well supported in terms of evidence. In other words, you don't need the patent office to do the evidence collection for you, like the courts do. So this is some facts for AA. And on the other hand, the civil suits is much slower. It really will take like 8 to even 20 or even 30 months for the courts to finish the first instance. But if the civil suits could award damages to the patent holder and can also grant preliminary injunction and interim injunction. So the civil suits is more suitable for cases that are technically complicated because the courts would usually have technical investigate officer sit together with the judge panel, okay, in the hearing. And the courts generally have the greater power in terms of evidence collection than the patent office. So if you have a case in front of you which you need some help from the court, you need the evidence submission from the other party, and the case is technically complicated, you should choose the civil case. Okay, so the evidence collection approaches that we're going to discuss in the next two slides are mainly regarding the court's routes, not the AA action in front of the patent office. Okay, so with this said, here I summarized the main approaches in China for a patent holder to collect evidence in patent litigation. So from the top to the bottom, the cascaded order stands for the priority for patent holder to consider in different types of patent infringement. So in other words, let's start from the very top. If your case fits in, meaning if you have a patent which is listable for the patent linkage system, then it's better for you to choose the patent linkage system to resolve the dispute rather than to go to a civil litigation afterwards. The reason is for the patent linkage system in China, the patent holder doesn't need to do the evidence collection, because under the patent linkage system, either the drug office or the generic company will provide necessary documents, necessary information for the courts or the patent office to do the infringement analysis. So in this way, all the materials that need to do the infringement analysis will be there, submitted from either the drug office or the generic company. So the patent holder will just initiate the suit and then do the analysis. That's it. So it's much easier for the patent holder. And I'll show in much detail of the patent linkage system on the next slides. But if you have a patent which is not, which cannot be listed in the system, so see for the chemical patents, we have like basically three types of patents that could be listed on the system, which is first the compound API, and second the composition, the formulation, and the medical use. And other than chemical drugs, we also have the patent listable for biological molecules. And also for that, for biological field, we could also list the medical use one, but there won't be any composition for the biology part. And then we have the traditional Chinese medicine. Also, for the traditional Chinese medicine, we have API, we have composition, and medical use. Okay, so we're gonna discuss the patent linkage system in the next slides in much detail. Okay, so let's see if you have a patent which is not, applicable for the patent linkage system, then the rest of the evidence collection mechanism usually needs to be based on prima facie evidence to show that there is highly likely an infringement to begin with. Okay, so to collect such prima facie evidence, we usually would do some investigation. It could either be done by attorneys itself, or could hire an investigator to get in touch with, in most of the cases, would be the dealer of the accused product, and then to purchase such product under notarization. Okay, so in China, this is very unique requirement from the court that purchase under notarization is has to be done instead of just simply buying something online or from some drugstore or something. So notarization is needed here. And also, this kind of notarization would help to fix the sample product as well as the selling activity of the dealer. Okay, so in this way, the sample product could be used for later judicial appraisal or testing. And then based on the type of the patent claim, in some cases, the drug instruction in China would also help greatly, because in recent years, I think it's 2022, we have a new requirement for the pharmaceutical company to put on their drug instruction. So they have to include more information about both API and also the formulation. Okay, so for some of the composition patents or even the API patents, you might want to check the drug instruction first before you go to appraisal or testing. Okay, but in some cases, if the information on the drug instruction is not enough, you might want to consider the judicial appraisal or testing to have an appraisal report as preliminary evidence to apply for, like the rest of the evidence collection mechanism, like let's say reverse burden of proof. So for example, if you have a new product, which I think it's also very common in other jurisdiction. So for the new product, which is like novel before the application date of the patent, reverse burden of proof could be directly requested for producing method patent. Okay, so but in China, the recent legislature allows the reverse burden of proof for the product which is not new. So in the case, if you have a product which is not new, but you could have the appraisal report showing the accused infringing product is identical to the product made by the patented method, which is a very strong evidence to apply for reversed burden of proof as well, to push the other party to provide their producing method. Okay. And the reverse burden of proof could also be applied to obtain damage evidence, like accounting books of the infringer. And for evidence that may be difficult to obtain in the future or may be lost, we have another mechanism called court evidence preservation. So this can be requested during the suit or even before the suit. Okay, in one of our cases, the accused infringer used patented product as intermediate to make end product and then sell the end product. Okay, and in this case, the patent holder provided an appraisal report showing the infringer's end product is identical to the patent holder's end product. And so based on this, applied for the court to do evidence preservation even before filing the suit, so that they could fix all the production materials, including such intermediates, at the infringer's factory. So the argument here is that the infringer can easily transfer and hide those production materials, including the intermediates, once the suit being filed and once the infringer being served. So in this case, you could ask the court to do evidence preservation even before you start the suit. And in our case, the court granted the evidence preservation successfully. In another case, we have it's a chip involved. It's a software infringement case. The patent holder provided appraisal report showing the function. The behavior of the accused chip is highly similar to that of the patented chip. And then based on this, applied for evidence preservation to get the source code of the accused chip. So in this case, the court finally agreed to do the evidence preservation, but the infringer refused to cooperate. And in such a situation, according to the Chinese law, if the infringer refused to cooperate, a court's evidence preservation, the court could directly reach the presumption that there is infringement without comparing the source code. Okay, so these are two examples showing. Yes.
I apologize for interrupting. I just want to make sure we give everyone time. Could we start wrapping up in about 2 minutes?
Oh,
Thank you.
Okay. Okay, so and then for the evidence that are not subject to lost or difficult to obtain in the future, we also have a court evidence collection. Okay, I think it's So this one would usually be applied to the cases where the evidence are kept by government agencies, or which is not kept by the opponent party or by a third party, which is related to the case. And under such circumstances, the court will issue some investigation order to that agency or party to get the evidence. Okay, and at the very end, we have the court on-site investigation, which is usually for the infringement involving large devices or products which are already installed in some particular places. So then the court will visit that place and do the comparison on site. Okay, so I'll just quickly go through the patent linkage. So here is taking the chemical drugs for an example. We have the database, which is quite similar to the Orange Book. And as I already introduced, there are basically three types of patents which could be listed for the chemical drugs. And it has to be listed within obtaining the market authorization 30 days. And then after the patent holder lists the patents, the generic company needs to make one of the four types of certification. It's quite similar to the US way. Either there is no patent or a patent lapsed, invalidated, or the generic drug promised there won't be any marketing until the patent expire, or the fourth one is the patent is invalid or not infringed. So under the fourth types of certificate, there will be initiate the suit. There will be 45 days for either party to initiate a suit before a court or SIN-IPA, which is the National Patent Office. Okay, and then there will be a waiting period for the NIPA to do the reviewing and not holding the approval, but the technical review will not suspend. And then after the 9 months, the NIPA will make the decision either to give the approval in the case if the generic win, and in the case if the generic company win, there will also be a 12-month of market exclusivity offered to that first successful challenger. Okay, so I think I made the time. So basically, that will be the end of my introduction today. We'll see you in the Q&A session. I'll pass the floor back to Carlos. Thanks, Carlos.
Thank you very much. I know this is a lot of great information and we're really tight with time. I'm going to go ahead and jump over to Takanori for his presentation on Japan. And the floor is yours, Takanori. Thank you.
Can you see the screen?
Yes, sir.
Okay. Nice to meet you, everybody. My name is Takanori Abe, and I'm going to introduce about the situation in Japan. The law provides several methods for the evidence collection, such as evidence collection procedures before filing the lawsuit, but nobody uses because it's not mandatory. I never used. And preservation of evidence, obligation to clarify the specific conditions, order for submission of documentation, and inspection. And for each, most of them are used only in the main lawsuit, not in PI. And some have a menu to protect the confidentiality information, trade secrets, but some do not. So let's see each of them. First, preservation of evidence. This is not impossible to use in IP cases, but typically it is used in the medical malpractice case when the patient wants to obtain the medical records from the hospital. And I have an experience of being used this, but it's not common in IP cases. And the order for submission of documentation, it's very different from the document production in the US discovery. The law provides two requirements: necessity and no reasonable grounds. No reasonable grounds to refuse. The typical example is there is a trade secret. And the statistics shows that 50 filings of this document production per year in IP department of the Tokyo District Court out of the 330 cases. So 1/6 of the cases, the parties try to obtain the evidence through this procedure. And you can use this document production to prove either infringement and damages and half and half. However, the statistics shows that so far the Japanese court issued the order to proof of infringement only in 2 cases. Why? Almost zero. It is because the IP judges in Japan are very afraid that once they grant such document production and the confidentiality information, trade secret are released to the opponent who are the direct competitor in the market, and ultimately the court finds there is no infringement and or the patent is invalid, then the outcome is that the trade secret is released to their competitor. That's what the Japanese IP judges are very afraid. That's why they are super cautious. But it doesn't mean that it is useless to file for the document production, because statistics shows that about 30% of the filings were withdrawn. Why? It's because the opposing party, when they are filed for the document production, they choose to submit some of the documents voluntarily without seeing the court order. So in some cases, it is useful. And if the court finds non-infringement through in-camera procedures, then court will determine no reasonable grounds because of the trade secret. And we have the protective order to protect the confidentiality information, but it is rarely used. It is because of the severe criminal or punishment. So attorneys are very afraid that nobody wants to go to the jail, so they hesitate to file it, and that is why the numbers are so few. And the first protective order case was Pharma. When the originator company filed a lawsuit, infringement lawsuit against a generic company, when they tried to defend themselves, wanted to provide highly confidential information about MA. And to protect their highly confidential information, even against the opponent, they filed a protective order which the judges granted. So this was the first protective order case in Japan. But although we have protective order, there are lots of problems in practice. For example, we have a technical session hearing when the attorneys explain the technology to the judges, but neutral technical advisors will be incurred contamination risks. And the employees of the party, whether they can attend the session, it is unknown. And also, it is difficult to watch compliance of protective orders, use of the secrets inside factories, improvement based on secrets, use of secrets in foreign countries. So these are the problems. And attorneys' practice are as follows. How to describe trade secrets in briefs. We have to be very careful. Describe indirectly, draft and submit briefs only with addresses of protected order. Describe trade secrets in separate sheets. And even the law doesn't say anything, but there is an article written by the judge that attorneys cannot share such confidentiality information with the secretaries. So attorneys should copy by themselves. This is impractical compared with the US practice. And how to communicate in the hearing dates in the court, avoid oral communication of secrets and not accompany employees, then very difficult to manage it. And when employees receive protected orders, keep contact information regardless of their transfer and the retirement. Even they are retired, the obligation continues. In the scope of addresses, the employees receiving protected orders, there is a risk of contamination and risk of violation of protected orders issued in the US if the US protective order says attorney size only, but if the Japanese protected order includes the company people. So you have to be very careful. And how about external experts who is receiving protective orders? It is unknown because the law didn't say anything. external experts can receive protective orders under current provisions, it is unknown. But we need to consult with our external experts for the technical issues, then how to do it, very difficult. And the patent attorneys who receive protective orders, they will have a difficulty when they do the prosecution job. So in practice, rather than issuing the protective order, the court encouraged the parties to talk and execute the NDA instead of issuing the protective order. And this is a voice of the users. The users want only the judges to see it, or if not, only the opposing attorneys, not the company employees. And we have another evidence collection method, which is called inspection system, which is introduced from the German system. However, unlike in Germany, where inspection system can be used before filing the lawsuit, in Japan, it is only used after the filing, but in practice, it could be allowed only at the end, meaning that after trying every method and failed. And so far, only one case tried challenge to have inspection, but the court denied, and nobody is successful. So it was introduced to strengthen the evidence collection method. However, the practice shows that it is not so much helpful so far. But we can utilize if there is an appropriate case. And the method invention, very difficult to prove because we don't have discovery. We don't know what method the opponent is using. We cannot go to the opponent's factory to investigate the method. So then what to do? But we have some clues. For example, we can utilize the indirect evidences. For example, the opponent maybe if there is 3 methods in this world, and the patent is using method A, and the remaining one are B and C, but in practice, nobody is using B and C, or opponent published the article regarding method A, or opponent have a patent regarding method A, then that could be a very good indirect evidences. And if we have many of the indirect evidences, then it is difficult for the opponent to deny. And also, when the plaintiff patentee draft a complaint, the defendant needs to say whether it is whether they will admit or not. But they should not only say not deny, but they should say the reason. Meaning that if they think that if they cannot say no, or only no, but they should say then it should be not method A, but it should be method B. But because defendant cannot make a lie, so in some cases, even there is no direct evidences because of this practice law, which says you cannot lie, so a defendant should confess that they're actually using method A. So in that regard, that will save the plaintiff. And because everything is reformed in the Japanese patent litigation, which was notorious for its slowness or low damage amounts, or but everything is reformed, and evidence collection is also reformed, but not yet perfect. So in some cases, we use the U.S. Discovery 1782, which is very helpful for the Japanese litigation. So thank you very much, and I welcome any questions.
Thank you, Takanori. Perhaps just one quick question. When you refer to at the very end that we use U.S. Discovery, does that mean you use results from the U.S. Discovery system, or something, or you're using the Discovery system itself in Japan? I didn't. Could
The
you
latter
flesh
one.
that out?
The latter one, the US 1782 is called US foreign discovery. Foreign means not US, and in this case, in our case, it's Japan. So the US discovery specifically for the Japanese case. So suppose I have a case in the Tokyo District Court, but the evidence collection method in Japan is not sufficient, then I can ask the US court to ask the opponent to submit the evidence, and then we use it and submit to the Tokyo District Court. We have used it, so this is a good clue.
Super. Thank you. Takanori, thank you for helping us keep back on track. We're going to jump over now to Korea. Ducksoon, please take it away.
Sure. Thank you, Carlos. Hi, everyone. I'm pleased to speak to you today about the discovery in Korean patent infringement litigation. Let me upload my document. Okay, before going into the slides, I'd like to start with a brief overview of the discovery in the Korean patent infringement litigation. Like other civil law countries, Korea has a limited discovery. However, recognizing the need to enhance the patentee's ability to get infringement evidence from an alleged infringer, Korea has introduced a few new discovery tools to the Patent Act in recent years. They include the material production order system, where a document holder can no longer object to opposing parties' document production requests based on a claim that the document contains the trade secrets, and the defendant's obligation to disclose the specific information on its own product or process, so that a simple denial of infringement by the defendant is not allowed. However, even with these new legislations, it may not be inaccurate to say that these new discovery tools have not yet been fully utilized in practice. Under the circumstance, a few recent dispute cases triggered another legislative movement to introduce inspection system, which is similar to German style, or based on Takanori's explanation, Japanese style inspection system, which I will explain further shortly. In these dispute cases, indeed, Korean companies filed a US ITC actions against their Korean competitors, alleging the misappropriation of their trade secrets by their Korean competitors, even though the misappropriation had occurred in Korea. Those ITC actions are reportedly initiated to take advantage of the broad discovery in the US ITC. With this background, I will begin by explaining some characteristics of Korean discovery. As I said, Korea has a limited discovery, and discovery requests must be focused and specific. No open-ended and broad discovery, like relevancy to the subject matter of the litigation, are not allowed. And there is no pretrial discovery in Korea. Unlike the US, discovery and trial are not conducted in two separate phases. Limited discovery is conducted during the course of hearing proceedings, which comprise a series of hearings held in an interval of several weeks. Each and every type of discovery, we need a court's permission. And discovery is conducted by or under the supervision of a court. For example, if an inspection request of the defendant's premises is granted, the judge himself will pay a visit to the defendant premises with plaintiff's side and preside over the inspection procedures. In Korea, admissibility of evidence is not an issue in civil litigation, meaning that any type of evidence can be submitted by the parties. The key issue is how much evidentiary weight the court will give to each piece of evidence. Now, these are the types of discovery that are available in Korean patent infringement litigation. By the way, These discovery measures are available only in main actions, not in the preliminary injunction actions. This is because the swift nature of the preliminary injunction case. By the way, in Korea, the preliminary injunction is not part of the main action. This is separate and independent from the main action. The first list includes the types of discoveries that are available under the Civil Procedure Act. The lower list includes the discovery measures that were recently introduced to our Patent Act, as I explained, in an attempt to improve the environment for patent assertion. Due to limited time, I will not go into specifics of each type of discovery, except for the evidence preservation, which can be sought even before filing an infringement action. If certain conditions are met, patentees sometimes attempt to obtain the infringement evidence directly from the defendant's premises, even before filing an action. This evidence preservation is just to preserve evidence. If the access to the evidence is likely to be difficult once the formal proceedings begin, due to the accused product or process being altered or otherwise compromised once the formal proceedings begin. Okay. In addition to the conventional ways of obtaining evidence that I have explained, I'd like to add a few additional comments. First, as Takanori mentioned, the US Section 1782 motion. As you know, this motion allows an interested person in a legal proceeding outside the US to apply to a US court to obtain evidence for use in the foreign proceedings. In particular, Section 1782 motion will likely be useful in patent disputes involving biosimilars, generic companies that have commercial partners or CMOs in the US. Next, the Korea Trade Commission action, KTC action, similar to KTC. KTC, like the US, enjoins the import of the goods infringing the Korean patent. However, unlike the US, KTC also enjoins the export of the infringing goods. In any event, KTC is empowered to require the respondent company to produce documents, information, and sample products. Thus, the KTC action sometimes is found to be a good source of infringement evidence from the defendant or respondent company. Additionally, I would like to refer to Korea Customs Service or KCS action. This is something similar to the European border seizure measure. Here, by registering patent rights with the KCS, you can receive a notification from KCS of the goods suspected of infringing the registered patent, if when such goods are declared with KCS for import or export. This notification may include useful information for related infringement action, such as the batch number or the quantity of the import or export shipment at issue. Now, as I explained at the outset, there is a pending bill to the Patent Act. The pending bill includes two significant measures. The first one is German-style inspection. Here, perhaps like the Japanese system, the court appoints an independent expert who is empowered to conduct inspection of a defendant's premises and also interview with employees of the defendant. After the inspection, the expert is supposed to submit a written inspection report to the court, which may be used as infringement evidence later by the plaintiff or patentee. The second feature of the pending bill is order to preserve evidence. Here, the court may order the defendant to preserve certain evidence which is essential for substantiating or verifying the infringement or damages. By the way, in Korea, there is no document preservation obligation on the parties to a civil lawsuit. So once this pending bill is passed, this will be just unique the discovery feature under Patent Act. Here, if a defendant in violation of the court order to preserve evidence intentionally damages or renders unusable evidence that is necessary to prove infringement or damages, the court may deem that the plaintiff's assertion regarding the fact intended to be proven by the evidence is true. And this is what I have prepared, but I'd like to emphasize that even with the limited discovery is available in Korea, you need not to get discouraged because we don't have the pleading requirement or specificity requirement in the complaint of the infringement action. So even without including any claim chart or specific infringement theory or argument, the complaint will not be easily dismissed. Instead, the plaintiff patentee will be given some opportunities to build up its own arguments and also evidence gathering by way of submitting indirect or circumstantial evidence or story to the court so that the court issue a discovery order to the defendant. I will stop here and we'll be happy to answer questions later. Thank you.
Thank you very much, Duck-Soon. I'm writing a lot of notes, and especially I think there's a number of great cross-jurisdictional opportunities that are popping up in my mind that could be taken advantage amongst the different jurisdictions and other ones. I think a couple of examples have been made to the US. Archana, I'd like to hand it over to you so you can help us finalize the panel and close it out and then jump into questions. So please take it away for India. Thank you very much. Thank you, Duxon.
Thank you, Carlos. Just give me a moment.
No worries.
Can everybody see my screen?
Yes, ma'am. We lost the screen.
Oh. Thank you, Carlos. I think pretty much like other jurisdictions in India, we do have a very effective discovery mechanism, which is one could be a court-mediated discovery mechanism, and the other could be kind of somewhat similar to what we call private investigation. Before I jump into the various mechanisms that are available in India for using the discovery mechanism in a patent infringement lawsuit, particularly pharmaceutical patents, before we file a lawsuit in India, typically there are two or three stages that are involved when you initiate a patent infringement lawsuit. One is collection of evidence, which typically is done in India through private investigation. And that kind of collection of evidence is essentially to bring in a lawsuit before the court. Unlike many other jurisdictions in India, you can bring a quiet limit action, which means that the product may not be there available in the market for you to, for the plaintiff to analyze. And that typically holds true in cases such as secondary pharma inventions, in particular, if it is an API, a new chemical entity, or a biosimilar. It may not be that difficult because through the regulatory process, there is some kind of mechanism to show similarity, because the defendant may be using the plaintiff's dossier for seeking approval of a similar biologic or a generic drug. But when it does come to formulations, when it does come to processes, and then we do file a quiet limit action, which is an anticipatory kind of an action, so that there is balance of convenience in favor of the plaintiff, that's when the products are not in the market. You really don't know what the exact process of the defendant is. And if it is a formulation or a polymorph, obviously, because the product is not there in the market, the suit is based on an apprehension. That's when the discovery, the court-mediated discovery mechanism does, come into being. So with that, I will so we do have an investigation stage before discovery, and overview of the discovery mechanism in India. And what this typically means is that, unfortunately, like in many other jurisdictions, we don't have something called as patent linkage, where you can kind of put up your commercial products with the relevant patents that are associated with the commercial product for the third parties. In India, most of these investigations have to be carried out to ensure that the product is not launched, particularly in the pharma sector. And that's kind of a very regular monitoring of the activities of a competitor, which means that this investigation for collection of evidence has to be done at regular intervals, so as to ensure, A, that your lawsuit is not premature, and at the same time ensure that you're not very late for filing a lawsuit. Because once the product is in the market, there is always a balance of convenience related issues that may be involved, which may then reduce the chances of securing a preliminary injunction. The second is discovery in patent infringement lawsuits. So when do we typically request for such kind of discoveries in a patent infringement lawsuit? Such kind of discoveries, as I said, is essentially done when we are asserting our secondary inventions, like a formulation, or when we are asserting that a process patent is being infringed and the end product is the same. So in India, when a person does assert a process patent, there is always a reversal of burden of proof. I only have to show as a plaintiff that the products obtained by my process and that of the defendant's process are same, and that's about it all. That's when the burden moves back to the defendant to show that their process is different from that of the plaintiff's process. Next comes the secondary patents, which is like formulation, polymorphs, extended release, things of that kind, where you have to kind of analyze the product to see whether the ingredients of that composition or the formulation are same as that of the patented invention. What are the practical applications of discovery tools is pretty much codified in our civil procedure code. And what are the challenges that we often face when we are using these kind of tools, discovery tools, in patent infringement litigation, and some judicial trends, which also include issues related to confidentiality clubs and for preservation of evidence. Why does it get stuck? I'm sorry. So pre-suit investigation evidence means collection of, hiring a private investigator or technical legal expert to obtain evidence, and then verifying if the infringing product or process exists or not. Collection of samples is only possible when when the product's already there in the market, and it usually becomes very difficult in quiet timid actions. If the product is there in the market, particularly for pharma or non-pharma, one has to procure the infringing product and obtain samples for for analysis in order to ensure that you can institute an infringement lawsuit. So then you have to document the infringing nature of the product, which is essentially done by claim mapping. So before you institute a lawsuit, claim mapping is a very integral part of, I think, all infringement lawsuits, but typically in India, you have to have that process in place. Technical analysis, before again you file a lawsuit, once you do have the product, you have the evidence, you've analyzed the product, it is sometimes becomes of importance to have some kind of an expert or an affidavit to analyze the test or the evidence that they have collected to demonstrate whether the infringing product falls within the scope of the claims, particularly where the product is already there in the market. And that may also include lab tests or engineering, assessments, which then along with your lawsuit is filed, evidence or affidavit of infringement is filed with the with the court. Some of the discovery mechanisms in India that are available, one is a discovery, which is again under the Civil Procedure Code of 1908, which is a pre-trial process in which each party is given an opportunity to obtain evidence from the opposite party. So this is again a court-driven, where you may move an application to the court for requesting evidence from the opposite party. The other, this is obviously, these are all after a lawsuit is filed. Interrogatories, and interrogatories is again a written question submitted by one party to an opposing party, with a set of questions to gain some specific information which is not within public, or which is within the specific knowledge of whether it's the defendant or the plaintiff. Production and inspection of documents, often requesting parties to disclose documents relevant to the suit. We've often seen such kind of requests which are made during, say, SAP litigation, where you have comparable licenses that have to be disclosed. And that's when the setting up of a confidentiality club does come into place. The third, another nature of discovery process is Anton Pillar orders. So in India, under Order 26, Rule 9 of the Civil Procedure Code, the court does provide the right to search premises and seize evidence. So you have a local commissioner that can be appointed by the court in order to ensure that if there is infringing goods at the premises of the defendant, a local commissioner goes there, makes a report, an inventory of the infringing goods, and places their report before the court for consideration of during the infringement lawsuit. Last but not the least is the use of the Hague Convention for collection of evidence. India is a member of the Hague Convention, and often when there is a litigation that is between two parties in another jurisdiction, and there is say for instance an Indian entity who may not be a party to the US litigation, but may be supplying to one of the US parties, for instance, an API, which is the active ingredient. you can move an application seeking judicial assistance for request of certain kind of information from the Indian entity. So in overview, this is just giving a very quick overview of what are the kind of discovery mechanisms that are available in India. I would then kind of jump into the issues of confidentiality club, that when you are requesting for discovery of some kind of maybe a process, maybe some trade secrets, technical know-how, particularly in pharma cases and biosimilar litigation or comparable licenses and SAP litigation. The Delhi High Court rules in particular, the IP rules of the Delhi High Court do provide and include a provision for setting up of confidentiality club. And this was the setting up of a confidentiality club is not recent, but it's now been codified in the Delhi High Court rules. It goes way back to almost 15 years ago, when the courts kind of, for the first time in the Westergaard case in India, who used to make a mosquito repellent, a confidentiality club was constituted only to ensure that if there are some kind of trade secrets, technical know-how, business business information, a confidentiality clubs are constituted, and members of the confidentiality club are very carefully selected, which could include external counsels, technical experts, and some representatives, which we call as externalize only. So this is a very, very common process or procedure in India for setting up of confidentiality clubs. And just to kind of name a few, or name a few cases, recent cases in India, where the Indian courts have allowed setting up of confidentiality club, are the Ericsson, a very recent Ericsson case, where the Delhi High Court, which is one of the leading IP courts in India, allowed setting up of a EO club in this case, and the parties were allowed to access documents only through the members of the club. So it's not even, if you need other members to be included, you have to kind of again move an application and seek a no objection from either parties. Then Pfizer versus Unimark, this was a Bombay High Court decision, and this decision was setting up of a confidentiality club and holding proceedings in the camera. And in a similar case, between the similar parties, this is where the Hague Convention on collection of evidence was used for a litigation between Pfizer and Mylan before the Delaware court in the US. So that's when an application for judicial assistance was moved before the Bombay High Court to seek some information from Unimark Remedies Limited for Pfizer's lawsuit in the Delaware court. Some of the significance of discovery in patent infringement lawsuits in India is that this does help you to kind of, at a very initial stage, it depends at what stage do you file it. It is done usually at a very initial stage. It just helps you to kind of focus on the issues of your infringement lawsuit, which may also sometimes lead to, a very early closure of your lawsuit, that in the event for secondary inventions, if it is a non-infringing product, formulation, or a non-infringing process, the lawsuit can be, decreed at the very first instance, rather than kind of taking it right towards, a trial, cross-examination process. If there is infringement, it helps you to assess damages, because in India, damages are available from the publication date. And as I said, that, you do get a fairly, when you do define your legal strategy, it just helps you to kind of focus on the issues as to what, what are the kind of reliefs one is seeking. Practical applications, I think this is very common to all jurisdictions of discovery tools. It would include interrogatories, document discovery for technical clarity, and inspection and technical experts. So sometimes when you do have interrogatories and evidence that's been placed before the court, you can appoint technical experts in order to kind of decipher as to what those reports actually kind of mean, and just to kind of simplify the entire process for the judge. Challenges in discovery, patent litigation is delays in compliances. That's one issue. Jurisdictional variances is another issue. And the third is the confidentiality concerns that, as you know, I think Abe-san also said, and Duksun also said that sometimes even if after the trial there is there is a non-infringement decided against the plaintiff, then by that time you've already kind of disclosed all the confidential information through the discovery process. So that is another issue that one faces in patent litigation. Some of the other notable trends that we've seen for cases for best practices for practitioners. One is the interdigital case versus Oppo. This is an SAP litigation in India, where for the first time, pre-trial discovery and relevance of third-party patent license agreements, which is something similar to comparable licenses, was permitted. And this was based on an earlier decision of the same court, the Delhi High Court, Ericsson, where SAP holder had to disclose details of the agreement and who are the chipset manufacturers in order for FRAND determination. So just to kind of, I know I'm running out of time, some of the best practices for practitioner when you are devising a discovery, a legal strategy in India. It's just that there is no one size that fits all. You just have to be mindful of the fact that, what are the rights and obligations that the court provides. You make sure that you make your craft precise requests or interrogatories where necessary, propose protective orders, and do engage in technical experts at the very early stage in order to kind of sharpen and crystallize the interrogatories and the discovery mechanism. Thank you. Thank you, Congress.
Thank you, Archana, and thank you for keeping us in time. We're down to the last 3 minutes, so I would honestly like to go through a lightning round with all the speakers to perhaps provide what I think would be quite interesting for our pharma colleagues. One, I'm just very surprised, happily surprised that there are a lot of mechanisms out there that could be explored in your jurisdictions for purposes of some discovery-like procedure to help in obtaining evidence. But in particular, to close off, is a lot of the finding out the purpose of the discovery in pharma is for it to be pre-launch, right? And for and to obtain the information pre-launch. So that's pretty quickly, potentially before filing a complaint, but not necessarily, right? I think linkage definitely helps, Sinlay, having that available, definitely. But in your jurisdictions in Korea, in Japan in particular, India, and Sinlay, perhaps for stuff not covered by linkage in China, are there any quick tips, 30 seconds for potential litigants? Which of the ones you disclosed are useful for them? So maybe starting with Sinlay, please.
So the question is for the patent infringement not releasable on the patent linkage system?
In your particular case, it would be pre-launch activities. What can you quickly find out, or what mechanisms would you use for litigation that would not be covered by linkage? So processes, I think, would be one.
So
what would be some quick tips there for potential litigants for pre-launch activities or before launch, basically?
Yeah, so I think if a patent is not listable on the linkage system, we would usually go under the order to first purchase the sample and then do the judicial appraisal or judicial testing to reach a conclusion, to see what, let's say for if a compound, is to compare the compound with the patented product, or if it's a method, you have to prove they're identical and then ask for the reverse burden of proof, right? So the judicial testing or appraisal would be necessary in China. And that will be the starting point.
Super. Duxun, how about you?
Well, I think pre-launch activities perhaps refers to the stockpiling issue. What I mean is from the generics or biosimilar perspective, they may take the position that their production of drug substance or drug product before the expiry of the patent is just for obtaining marketing approval purposes. That means just a BOLA exemption on the US law or test and experiment exemption in some Asian countries. But in Korea, the BOLA exemption or test and experiment exemption is what the implementer, meaning that accused infringer or generics, needs to prove. And therefore, from the patentee's perspective, I think if you can show some reasonable suspicion of their pre-launch activities, I think we can get the burden of proof shifted on the generics or biosimilar side. Indeed,
Super.
we had one particular case where the patentee succeeded in shifting the burden of proof on the death circumstance on a biosimilar company who fails to meet their burden of proof, and therefore the preliminary injunction order was issued.
Archana and Takanori.
So I think, when we do talk of pre-launch in India, we often in pharma litigation, what we've seen is most of the actions are quiet timid actions. And being quiet timid actions, and in the absence of a patent linkage, there has to be, on behalf of the plaintiff, the patent holder, there has to be continuous monitoring of the activities of the defendant, because else there is no other way that the plaintiff will ever become aware of the infringing activities of the defendant. And once the product is launched, as Duxon said, that there is a lot of stockpiling, the markets are flooded with the product. And once they're flooded with the product, the balance of convenience is then never in favor of the plaintiff. And it's very hard to get an order from a court to say, let's recall the products. And that recall the products, the infringing products. And that becomes worse off that if the patent is not being worked in India, in the sense that the patentee's product is not approved in India. And if in those situations you ask for a recall, the first issue that emerges is public interest related issues, which means that, what do you do with the patients who are already on the defendant's, generic product? And can this entire infringing activity be somewhat compensated by damages?
Thank you, Archana. Takanori, to close us off.
Yeah, if the case is between the originator and the generic or biosimilars, usually the fact that the generic biosimilars had applied for MA is confidential, so originator do not know. And once it is approved by the ministry, then originator will understand it, and if they can obtain information regarding the generics or biosimilars, they can file PI immediately, even before launch, and or after the launch. And the exceptional case is that, especially in biosimilar cases, some biosimilar companies announced that they sought MA because they view that the risk of being sued they compare the risk of being sued and having a published announcement that they are seeking the MA for the marketing purpose. They emphasize the marketing purpose more. In that case, the originator company will understand that which biosimilar company had sought MA and can prepare to file the lawsuit quicker. And if the case is originator versus originator, then the fact that the opponent originator sought MA is public, and even during the MA process, the patentee can file the lawsuit, or even before that, during the clinical trial stage, the patentee can file the lawsuit. Actually, we represented the plaintiff patentee filed the lawsuit while the opponent originator company was conducting the clinical trial.
Thank you very much. Thank you very much to the panelists. I have not done my job well. We're 5 minutes over, but I think the presentations have been great and illustrated what the available mechanisms are, these differences, but I see some great opportunities here. Again, thank you to the speakers as well for connecting to a Europe and America friendly time zone. Appreciate that sacrifice of connecting so late. I also have been asked by AIPPI to remind you that our next webinar will be the third diversity and inclusion webinar on neurodiversity in the IP world. That's on 18 November in 6 days. Keep an eye out on the AIPPI LinkedIn account. And also just to remind you that the super early bird registration for the 2025 AIPPI midterm meeting closes on 26 November. The midterm meeting will be 2021 February in Croatia. Sounds like fun. So encourage you to sign up for that one as well. Thank you very much. Thank you very much to the AIPPI team that helped us organize the webinar, and thank you to the audience for hanging in there. I was asked if the slides will be available after the event, and the answer is yes. Upon request, please send an email to events@aippi.org. Really great material. Thank you very much again to the speakers. Congratulations, and I hope you have a great evening, great rest, great day. Thank you very much.
Thank you.
Thank you, Carlos.
Thank you.
Thank
Thank
you,
you,
Carlos.
guys.
Bye, everyone. Thank you.
Bye-bye.
Bye.